From western New York State and the Niagara Woodland Campground, only 20 miles from Niagara Falls, comes the Reynolds Reveal, the show that sifts and winnows without fear or favor. Good afternoon, ladies and gentlemen. I am your host, Morgan Reynolds, and we here at the Guerrilla Media Network thank you for listening in. Today is August 21, 2013, and this is episode number 25 of the Reynolds Reveal. Regular listeners know that I'm on an extended camping trip, trying to avoid work. Even a retiree, we can escape. Yet I'm trying to do the Reynolds Reveal on the road. Now, sometimes this works, sometimes not, and we were a little shaky here at the beginning, but I'm hoping we can complete our 2-hour show. Yesterday, my wife Pat and I visited Niagara Falls. That's my second visit, but I spent more time. And it was a great time ogling the Horseshoe Falls and the Bridal Veil Falls, the whole works. And to see 4 Great Lakes empty into the Niagara River and into Lake Ontario, it is just incredible, a feat of nature. And today we went to the old Fort Niagara, and that was very enjoyable because I think I know a thing or two about U.S. Colonial history, and yet I didn't know really about Fort Niagara, although you think about it, yeah, this is a choke point, and water transportation being so much cheaper than hacking your way through the northeast woods and the mountains. It was important to hold, and learned about the British throwing out the French, and then the Americans throwing out the British, etc. And it's just really some great stuff. So I recommend touring in this area. So I've had an enjoyable time. Maybe I haven't done my homework here quite as intensely as I ordinarily do. Okay, so my special guest today on to business is Counselor Jerry Leaphart, or Esquire, an attorney at law. And I guess lawyers somehow since Shakespeare or before acquired this negative reputation, but here is a man that I can endorse without reservation, Jerry Leaphart. He's a resident of Connecticut near New York City and therefore New York State. He's a graduate of the law school at NYU back in 1971. And he tells me his first 20 years or so were spent as a corporate lawyer in the energy industry of all things. And you're going to learn more about how he has taken the other side of the energy industry in court. So, Jerry Leaphart, welcome. It's an honor to have you on the Reynolds Reveal.
Well, thank you, Morgan. As usual, it's good to be with you. After you listed out my embarrassing background, I don't know quite where we're going to take it from there, but all right, you did it, so now...
we're going to be lifted by your acumen and wisdom and experience. I'll tell you, I have an interview with Jerry Leaphart on my blog called NoMoreGames.net, and I read that, finished it today, and there's an awful lot of insight there. That was back in 2010, so it's been almost 3 years. But let's go to more immediate matters. I do want to review much of that material because it's important. So few people know about our federal cases involving the substance of 9/11 and the fraud thereof. But I got an email from you today, and you are acting against NSA or to reveal what they have snooped up on you. So tell us about that.
Well, Morgan, we all knew in our intense review of what happened in connection with the events of 9/11 that it was important to stay on the trail because other events that would be as catastrophic or as alarming would continue to take place in the absence of vigilance. Now, on one level, the revelations concerning the extent to which we are all being spied upon by NSA are important in their own right. These events are also representative of an ongoing issue, an ongoing problem of having a governmental apparatus that cloaks itself and its operation in multiple levels of such that it's virtually impossible for even officials at the highest governmental level to fully know or apprehend what is being done under their watch or in their name, let alone in the name of the people that they purportedly represent. The NSA revelations, which came about as the result of the actions of a whistleblower, are, I think, crucial in the sense that the status of whistleblower is one that we should probably revere. I think it was...
Yay! Yay for the whistleblowers.
Yeah.
I mean, how can a republic or a democracy really operate successfully if so much is done in secret? It cannot be done.
No, it truly is a staggering danger. One about which we've had numerous important warnings over the years. One that of course stands out and is frequently mentioned is that of then President Eisenhower's January 1961 military-industrial complex warning. He was, and he said it in such a deadpan, matter-of-fact fashion that both at that time and even now, it's very difficult to come to grips with the full meaning and the full significance of what was being said at that time about the power of these entities to not just shape events, but to do so in a manner that is just amoral.
Yes, that's the first level to talk about before illegalities or unconstitutionalities. Yes.
Yeah, I mean, those are just obstacles for them. So it's I try to phrase my thought about this matters of this nature in a way that does not immediately jump into speculation or into conspiracy. When you do that, you're always guessing, and when you're guessing, you're probably wrong, and therefore easily marginalized for good reason. So one of the additional benefits of what Edward Snowden has done is that it has revealed that much that would have been dismissed before his revelations as mere conspiracy theory are now revealed to be fact. So that gives us something to work with. Now, you mentioned that.
And now here's a thought. I want to let's speculate for a moment, despite your negative claim about that. But somebody made the point in an article I was reading this morning about how hard they're fighting. For example, they detained Greenwald's domestic partner, whose name escapes me, David in vitro.
David Miranda.
Miranda.
That's extraordinary.
And it's an intimidation ploy, at least in part. And the writer was saying, why are they going so hard? They've been exposed in lie after lie about NSA behavior. And the thought occurred to me, they have to cover up 9/11 is the biggest crime these guys have committed. Something could come out. Who knows? That whistleblowers reveal inside. It's just an important thought, I think, about their motivation, about why whoever is heading the executive branch has got to go so hard after a Snowden or anybody else.
Well, this issue of how hard they are going after Snowden and anyone connected with him, Greenwald, Miranda being the two current examples. But let's explore that a little bit, Morgan. Put yourself in the position of, once again, I might add, of being a high governmental official with a security clearance, and let's assume that you have access to classified information, compartmentalized information, and that something about things that are going on that are presented one way, but in public, but are quite the opposite based on the information you have access to. One can you don't have to imagine to be able to know that at this point, virtually all of the nearly 1 million people who have security clearances are probably being placed under extraordinary additional scrutiny themselves. I mean, if anyone with a security clearance at this point sneezes at the wrong time, they're probably going to come in or come under additional pressure. Now, I think, Morgan, that it is precisely because of pressures like that at some point additional whistleblowers will more likely come forward. It's the system based on what Snowden has been able to accomplish, and to a lesser extent in terms of consequences to the individual, what Bradley Manning has been able to accomplish, do suggest to us that people who are on the inside, who have access to this information that they know is proof of intensely illegal, not to mention unconstitutional activity, are at this point, I think, the considered to be the among the greatest threats to the power structure and the powers that be.
But now, Jerry, you, given your special skills, training, and experience, you approach this, at least in part, as an attorney, and can take actions in the court system, which is it's a privilege and potentially a powerful way to proceed. So what are you doing specifically with the NSA?
Well, specifically with the NSA, I did request that they release information that they may have collected on me, and any person can do that. Any person can submit a Freedom of Information Act, or as we call it, FOIA, request to NSA. You just have to go on their website and click on the section that is entitled FOIA, And you will, if you submit your request, you will get a prompt reply from NSA that will be very courteous, and it will say that they are going to look into your request and they are going to promptly get back to you. And then after a few days, you are going to receive a 2 or 3 page letter, very politely denying your request for information. That denial letter will contain a reference to statutes, that is to say laws, that you never knew existed. It will contain a reference to regulations that are denoted by long chains of numbers and letters and parentheses that, if you go and look them up, the regulations.
In everything but Latin, right?
Everything, not just everything but Latin, Morgan, but the key point is that they will make reference to everything except the Constitution. And therein lies the real issue. Morgan, it is simply not constitutional to invade people in the privacy of individual citizens.
Fourth Amendment being prominent. You are listening to the Reynolds Reveal, and my guest, attorney Jerry Leaphart, will return with more of his battle with the NSA and with nest contractors and ultimately the issue of 9/11, the source of so much of our evil in the world today. Welcome back to the Reynolds Reveal. I'm your host, Morgan Reynolds. And if you would like to call in and speak with attorney Jerry Leaphart, who is moving against the NSA, and we'll learn more about that in a minute, the number to call here at the Guerrilla Media Network is 218-862-9829. Now, Jerry Leaphart, before the break, you were telling us about your dealings with no such agency. I don't hear that anymore. It seems like the whole world suddenly knows about the National Security Agency. At any rate, you filed a FOIA, as I understand it, to recover all the information that they had gathered on Jerry Leaphart. Is that right?
That's correct, Morgan. And that is, it's an ongoing process. We had talked about the fact that shortly after making the request, a denial letter was received, and then under the regulations that govern FOIA requests, if your request for information is denied, then you have the right or the opportunity to appeal, and in the appeal you basically set forth your reasons for the appeal, and so that's what I have recently done, and I would expect to receive a response denying the appeal within probably a month or so. Now, beyond that, it might require more formal legal process of taking the matter into federal court.
So, Jerry, I'm the layman here. Does all this bureaucratese, legalese, what did it amount to? Is this a matter of... Go ahead.
Okay, well, what it amounts to is it's legal process, and Morgan, you actually, I think, said it best in the prior segment. You referred to the fact that attorneys do have the privilege of being able to represent people and to present their issues, grievances, and cases in court. That is what we do, and the value of legal process can be both overstated and understated in connection with matters of this nature, matters that are really seeking to assert issues of public policy, issues of civil rights, and of constitutional protections. I mean, that is what this is about in the bigger picture, with the details or the circumstances being, I won't say that they are incidental, but they are merely representative of what it means to petition one's government for redress. So among the many subtexts of a process of this nature, and the way that I was able to craft it based on my personal circumstances, is that I was able to point out that having taken a stance that the common storyline of 9/11 was false, and having worked with people such as yourself and such as Dr. Judy Wood, who had painstakingly discovered and published information as to what had happened on 9/11 with respect to the mechanism and the manner of the annihilation of the World Trade Center. Having done that and having been involved with the scientists and people who had done that, I had good reason to think that NSA would have information, upon me.
Could find you of that. It also occurs to me that you have been a Quaker, correct, and probably still are. And Quakers are always, possible enemies of the state because of their opposition to war.
Right. The Department of Defense clearly and in writing considers Quakers to be a threat. And so, that's sad.
It's sad. It's also laughable. I was recently in Pennsylvania, where my wife was born and raised, on the Susquehanna River there in Sunbury, east central Pennsylvania. And it always occurs to me, Benjamin Franklin is probably the best known figure from the Commonwealth of Pennsylvania, but William Penn founded the colony, and the Quakers were so important in the early days of Pennsylvania, and Pennsylvania was the most prosperous colony. Why? Because it was the freest. It had the rule of law, and it was the freest and most prosperous. And I say, hey, this is all a bad thing. No, it's not. It's not bad at all.
Well, it sounds like you have a pretty good grasp of Quaker history there, Morgan. I congratulate you on that. But yes, I'm a Quaker, and I have attended events that I am relatively certain were being monitored, and even more certain than that there are infiltrators who are, specifically there to in effect, if not monitor, then certainly to also participate in proceedings to make sure that they don't, take a turn that is not favored by, the powers that be. Now, I'm not prepared.
Okay, Jerry, I've got to ask a question, and I'm not going to name the person, but I understand that you have positively ID'd one of the intellectual leaders of the 9/11 Truth Movement who was involved in this monitoring or infiltration. Is there anything to that?
Well, Morgan, I hesitate to go in that direction, So why don't we put a hold on that one until perhaps another segment? There are a number of issues associated with that.
You don't have to name anybody, but I'm just if there's any continuity here, it's sort of like and I'll mention Stephen E. Jones, who was so important in what should we say, thwarting. The whole issue of low energy nuclear reactions, cold fusion was the name that stuck, and the source is Jones. And then they trot out the same guy to mislead on 9/11 research. So some of these people are used in the new circumstance or the new quest to reaffirm the state's dominance. That's all. So,
right.
All right. Well, I interrupted by going in that direction, but you have the experience of Quakerism there.
Yeah. So getting back to to how that appeal works, by mentioning the reasons why you think you may have been the subject of NSA spying or metadata collection. That is one factor to be taken into consideration in whether or not the denial will be reversed. So there are other approaches that that people can take, but an additional benefit of saying what you have done that you think gives rise to the possibility that you may have been monitored, or that substantiates the reason why you have this concern and want to know what data they may have collected on you, is that you are taking a stand that you are not a threat and that you are merely exercising the rights and the privileges that a citizen should exercise. So in and of itself, by doing something like this, you are taking issue with the fact, among others, that the U.S. Department of Defense considers you a threat. That's offensive, and that should be countered. If I haven't said this directly before, I'll say it now. The United States Department of Defense has no right to consider peace activist threats. That is intolerable, and that must cease.
I agree, and it's intimidation, even
that
if
is correct.
It certainly is contrary to freedom of speech, and there's enough hooks into people, especially the career ladder, to shut them up already. It's just there'd just be another now coercive threat, a new layer to suppress the American people and turn us all into proles or subjects of a regime, no longer citizens.
Right. I think at this point, Morgan, we know that the typical and oft-repeated reaction to revelations like that of what NSA is doing goes along the lines, well, I've not done anything wrong, so I don't have anything to be afraid of, so, let them spy upon me if they want to. Now, that's not word for word how that is usually phrased, but it's remarkable to me that the way that it is phrased is repeated from one individual to the next on almost a word-for-word basis. If I've heard that sentiment expressed once, I'd say I've easily heard it expressed 1,000 times. Now, the point is that if you have that mindset, then you are committing yourself to also assess, what opinion do the powers that be want me to have? And then when you find out what opinion the powers that be want you to have, then you have it. So
Right.
therein lies the complete surrender of what it means to be a free human being. Yes, you may be happy, but you are not free if you acquiesce in being spied upon to make sure that you are not a threat. That spying should not take place. The definition of threat has next to nothing to do with terrorism, and that's also a part of the appeal that I filed. And if we're coming upon break time, then what I would do, Morgan, is go into that issue of threat and terror in the next segment.
Okay. Hey, I've got a thought for you, though, and that is politically, or in terms of public opinion, I think that the President Bill Clinton impeachment process proved that the American people didn't mind him lying under oath, at least in principle, I'd say, perjuring himself, because the American people, a clear majority, heavy majority, made it known that they didn't want federal prosecutors investigating people's backlogs. Okay, on that note, sex, so we're going to talk sex on the other side of the break. This is the Reynolds Reveal. I'm your host, Morgan Reynolds, so come on back and get attorney Jerry Leaphart's take on the sex, the denial under oath. Welcome back to the Reynolds Reveal. I'm your host, Morgan Reynolds, and if you would like to call in, we do welcome callers here at the Guerrilla Media Network. The number 218-862-9829. Now, before the break, I, in a ham-fisted way, was trying to make a point here, which actually boils down to, I think, jury nullification. But what happened with Bill Clinton was basically the American people didn't like the prosecution promoting an impeachment in the U.S. Senate based on perjuring himself in what it amounted to was sexual mischief. And Jerry, is there anything to this in terms of a point of law, this analogy I'm trying to draw?
Well, perhaps, but the one thing that I can say about that is that every instance that I know of where in a case that did not involve a sexual assault, or where the matter of some sort of sexual intimacy was not the issue in the case, if you tried to bring that up at a deposition or in a trial or in some other way, no judge would allow that. That's off limits. And so the one exception to being able to use law or legal process to pry into and then make an issue out of sexual activity between two people was that matter. So basically, what I think.
Okay, here's a better word. Here's a word that has been tossed around in view of the surveillance state we're living in: privacy. And well, some people say I've done nothing wrong, so there's nothing to fear from an all-seeing Orwellian 1984 state. But it's clear that I think we learned from the Clinton case where basically the Senate said, well, we're not going to go for this, even though the guy clearly lied under oath because it's about sex. So some matters are to be private.
Yeah, that's the way that matter would have been handled in a court as well. And except that a court would have gone further, I think, Morgan, and would have reprimanded the attorneys who tried to bring up the issue in the first place.
So the courts would have done a better job than the political process.
Yeah, right. But but that's the key point. It's a political process. So therefore, in political matters, there's a different calculation involved. But let me dovetail back into the NSA data collection, and that also, in my individual circumstances, did have a tie-in to 9/11. And the way that worked is as follows, Morgan. We now know, as a result of the Snowden revelations, that the metadata collection apparatus is so all-encompassing that virtually, anything that is digital, anything that is transmitted via digital or electronic process anywhere in the world is stored, is traceable, and can be used. Now, we are finding that out such in a way that no longer allows making that statement to be considered a conspiracy theory this year in 2013. But the issue here is that these capabilities are not new. These capabilities have been around for ever since there have been computers, and ever since the advent of digitally transmitted information. And NSA was undoubtedly not the first. They were the second to ever have this capability or these capabilities. Now, the point here is this. With respect to 9/11, we know that the 9/11 Commission went to great lengths to say that they could not trace the financing of the events of 9/11, and they could not determine who financed or who was behind the bankrolling of 9/11. And if you take a look at the 9/11 Commission report and at the 9/11 Commission staff monograph on finance, you will see an incredibly simplistic recounting of how they went about supposedly determining as much as they could about the financing of 9/11. Nowhere do they mention digital information. Nowhere do they refer to the collection of data. The entire process of determining who financed the 9/11, as you look at the 9/11 Commission report and staff monograph, is sourced to a number of interviews that they had with named individuals. So what this tells you is that there really was no attempt to find out who financed. And
nor did we expect it.
Yeah, nor did we expect it. But with respect to now finding out what capability NSA actually has and have had for quite some time, it certainly opens up the question of, hey, if you know every detail about the comings and goings of Morgan Reynolds, and you know that as we speak, exactly where he is and what he is doing and so on, and if you know the same information about Jerry Leaphart, then let's do a FOIA request on what information you had concerning the 9/11 terrorists. That's a FOIA request that is sitting out there, that perhaps, Morgan, among your listeners, there might be some interest in pursuing.
Yeah, that seems reasonable. Have you, by any chance, read Daniel Hopsicker's book on, I can't remember the exact title, but it's basically about Mohammed Atta and company in Florida? I've read only a sample of it on my Kindle.
Yeah, that's all I've done as well. I have read, reviews of it and, and samples and snippets here and there.
But we have also, of course, on this issue, Robert Mueller, the FBI director for some years now, to be, I guess he was recently replaced, who denied that there was any record left by the terrorists. He made a very sweeping statement about how there was no paper trail left by the terrorists.
Yeah, no paper. NSA does not collect paper data. They collect digital data.
Okay, so maybe he was lying by commission there by.
That's an easy one for him to have gotten around. It's misleading. It's extraordinarily misleading. It's dishonest. And it's disingenuous and all of that.
But you're making a good point. For example, I'd call them patsies that the FBI identified. Of course, we know some corporate media interviews found at least 7 of them alive, but they had no visible means of support while they were running around getting lap dances and boozing it up at some clubs they were seen at. By seemingly reliable witnesses, et cetera.
Yeah. Well, no aspect of that story really survives very well when put to scrutiny and when put to analysis. The problem that you have is that when you scrutinize it and when you analyze it, you are still too easily marginalized as a conspiracy theorist. So the advantage that we have at this point with and based upon the revelations about what NSA is up to and capable of is that we can pursue that.
Everyone, including the commissioners, has disavowed the 9/11 Commission report. You are listening to the Reynolds Reveal, and we shall return after the break with more Leaphart. Welcome back. You are listening to the Reynolds Reveal, and I'm your host, Morgan Reynolds. And if you would like to call in and discuss 9/11 with Attorney Jerry Leaphart, the number 218-862-9829. And Jerry Leaphart, is it time to let's review these 9/11 cases you brought in the Southern District of New York, which are the only cases I know of, and correct me if I'm wrong, that challenge the substance of 9/11. Of course, there's a lot of conventional cases seeking damages from various parties and the like, but there's they all accept the common 9/11 storyline, as you put it.
Well, yes, that is correct. And it, once again, if you're going to engage in legal process, then you have to do so on the basis of coming forward with both a theory of a case that is based upon a right to bring the kind of case that you are bringing, and it has to name the proper party, and it has to proceed on the basis of factually based evidence and information. Your case and that of Dr. Wood, Morgan, were based upon the False Claims Act, and cases of that nature are referred to as qui tam cases. In order to bring a qui tam case, You first.
By the way, Jerry, could you give a literal translation? My high school Latin spelling McKee, Q-U-I, and then a separate word T-A-M. What's the origin of that expression?
Yeah, it's Morgan. Even if I try to do that right now, I'm going to butcher it. But it's basically you're bringing a case in the name of the crown, because this derives from English law.
Yeah.
And
makes
so
sense.
and it has survived into American law. But basically, what it amounts to is that you are a citizen bringing a case in the name of the state or of the government, based upon the fact that the government does not know that it is being defrauded. Okay?
Yes.
So a key.
So it's a form of whistleblower statute.
Yes, it is. It is. Yes, it is. It is the statute that is used by whistleblowers. Now, cases of this type are very welcome in the federal court system when they involve claims of things like Medicare fraud. If you have information that a doctor or a hospital or physicians group of some kind has overbilled, and you are the source.
That's ordinary thieving. Yeah.
So then a case of that nature is very well received in federal court, and so it was with your case. You went in and you said that the National Institute of Standards and Technology that had been authorized by Congress to determine why the World Trade Center, self-annihilated, was based on fraud. And what you said was that the contractors that NIST relied on and that who received the better part of some $16 million had gone in and intentionally misled NIST as to what had actually caused the destruction of the World Trade Center, and had come up with basically an untenable probable collapse, probable initiation of collapse sequence that by definition did not address why and how the towers were destroyed. So not only did they not determine why and how the towers were destroyed, they did not even answer the question that Congress had mandated NIST to answer. Now, let's take a cynical view, Jerry, i.e. realistic. What they did do was spend $20 million of taxpayer money. They hired a bunch of prestigious contractors, and as you put it in a previous interview, they committed a scientific fraud. They produced 10,000 pages, and kind of the normal non-alert citizen living his or her life would at most say, "Oh, okay, yeah, the government investigated it." They came up with the conventional conclusion, so everything's fine. So right.
it's
that is what they did, and not only were the contractors that they used prestigious, as you referred to them as being, Morgan, they were also the cream of the crop of the military-industrial complex, the cream of the crop of the process by which exotic weapons of the type that were determined to have caused the destruction of the World Trade Center. These are the companies that make those weapons. So with that information,
well, let's name them the top two, Jerry, and tell us
the top
more about.
I never tire of mentioning Science Applications International Corp. and Applied Research Associates Incorporated. Science Applications International Corp., also known as SAIC, and Applied Research Associates, Inc., also known as ARA. Not only are these companies that are heavily involved in the manufacture of exotic weapons, but they are also founding members of the Directed Energy Professional Society. That entity is also closely linked to the United States Directed Energy Directorate, headquartered in Albuquerque, New Mexico. So,
which is where ARA's headquarters is.
Which is where ARA's headquarters are to be found as well. So, for those who, let Google be your friend, and just start with ARA, Applied Research Associates, Inc., and also start with the Directed Energy Professional Society, and just Google and peruse the information that comes your way as a result of of doing so. And in so doing, you can get access to information that is almost as revealing as the Edward Snowden NSA disclosures about data collection when it comes to the issue of exotic weaponry.
Now, isn't it, Jerry, that Dr. Judy Wood has proven beyond a doubt to my mind that directed energy weapons destroyed the World Trade Center, and here we have the two leading companies that NIST hires to investigate the destruction happen to be the leading producers of directed energy weapons.
Well, that's correct, and so that was the theory of our case, and we provided to NIST the information leading to the conclusion that the World Trade Center was destroyed by such weapons. And NIST, to its credit, published that data and that information on its own website. NIST is a part of the United States Department of Commerce. And the United States Department of Commerce contains that information. So it is a part of the public record. So having provided that information to the government, having been the original source of the providing of that information to the government, you and Dr. Wood satisfied the criteria for bringing a key TAM case. You could represent the government in this instance because you were the source of the information and you gave the government the opportunity to pursue it itself, because when you filed your complaint, you did so on a sealed basis so that the U.S. attorney could decide whether to pursue it or not. If the U.S. attorney decides not to pursue it, then the U.S. attorney has to let you know that they are declining to pursue it, and then that in turn gives you the right to unseal your complaint and go for it. And that is what you did. Okay? So you were then met with the combined forces of some 17 lawyers of record for the military-industrial complex and illustrious companies who were involved in this NIST process. And they fought you tooth and nail in order to make sure that your case did not survive to the point where you would have been entitled to undergo discovery, that is to say, request documents and information from them. Had the case survived to the point where you would have had the right to demand documents and information from them and to depose the people who participated in the NIST shenanigans, I think the other side would have been forced to discontinue the case with you, and the only way they could do that is settle. That is to say, repay the money that they had been paid plus triple damages. So,
well, that wouldn't have been satisfactory to me.
Well, it's again, as I said at the outset, what you have to do in bringing a case is that it has to be based on a theory that gives you a right to bring the case. It has to be based on suing the parties that you have the right to sue, and it involves bringing forth factual evidence and information. Now, yes, that is
okay.
Both
So
hold on.
We could have won by the conventional standard of victory, but they would have escaped the revelations that would have come from informed and hostile questioning.
Well, you never say that your question. If you're in legal process, you don't say that you're engaging in hostile questioning. You're engaging in a process where
discovery. We're in discovery.
Yeah, well, it's a process where you simply are requiring that they come forth with what they know, whether they want to or not. That they have to be forthcoming. So it was, the case had possibilities, but in the end, the decisions went against you, so you didn't have the opportunity to get to the discovery phase. However, we do look upon.
Okay, now you're semi-retired, Terry.
Yeah.
My question goes to the court. Now, did we get a bad draw? I mean, George B. Daniels, the judge, was basically the back of the hand. He didn't accept as truthful our factual allegations, and we just didn't get a fair hearing. Now, that it could have been the case that anywhere in the federal system, the cynic would say, well, the idea of an independent judiciary in the federal court system is nonsense. But we might have gotten a bad draw. We might have gotten a more sympathetic court. I don't know. I mean, I don't have the experience you do.
Well,
certainly,
whenever you bring a case, and as soon as you find out what judge it's being assigned to, you do a little research on the kind of judge that you have. You call your friends and say, hey, have you been before this person? What's he or she like? You look up cases and decisions they may have previously issued, and you analyze them for style and tendency, point of view, and things of that nature. And so we did that with respect to Judge Daniels. What we found was very much a mixed bag. And that's about as much as I think I want to say about that in this segment. I can talk a little bit more about it if you like in the next.
All right. Attorney Jerry Leaphart is our guest today on the Reynolds Reveal. So come on back and let's talk 9/11 in the court. Welcome back to the Reynolds Reveal. I'm your host, Morgan Reynolds, and if you would like to speak with Attorney Jerry Leaphart about 9/11 and the cases they're involved, the number is 218-862-9829. And I want to put in a plug for Jerry Leaphart as a former client, as a plaintiff, and he is very judicious, as you can tell, and he would have made a fine judge had he chosen to go that direction in his career. And nonetheless, Jerry Leaphart, and I say nonetheless because maybe he's too judicious sometimes. He may not sound like the most aggressive attorney, but he is superb. He was superb. I just as a plaintiff client, I just had found no fault with Jerry's performance, and I'm sure many clients or plaintiffs are on hindsight dissatisfied. That's the way it goes, but Jerry did a superb job in my case, and the other two, to the best of my knowledge.
Well, Morgan, it's certainly heartwarming to hear you say that, and I do appreciate it very much. But in your cases, I had the advantage of having really well-prepared clients who, were right there every step of the way, providing basically the information upon which the cases, were based. And certainly in the case of Dr. Judy Wood, she followed that up with the publication of her book, Where Did the Towers Go?
Yes.
Which ranks as, I'm sure that will be a book of historical significance. It is extraordinarily well written. It's just a gem of information as to what happened, on 9/11. What I would also like to say is that...
let me ask a question. Go back to the law. Because Judge Daniels dismissed at the circuit court level, or district court level, he dismissed our cases with prejudice. And on my blog, I answered all of his. He rolled up 3 cases into one at the request of none of the parties. He did that on his own. And it was really a very, as I said earlier, back of the hand dismissal. And he did it with prejudice, which ironically, if you look at the word prejudice, it's to prejudge. And I say, that fits here because he didn't really delve into our case or, in my opinion, take it seriously. And some of his claims were flat out wrong. But then you ask for a reconsideration or put forward some motion, and he dismissed that within 24 hours. Now, however, he did not grant the sanctions against us that the defendants pleaded for. And that was an important exoneration, you might say, on our behalf. And I'm wondering what is involved there. Would that have been, suppose he had granted sanctions and tried to justify it, would that have possibly been overturned at the appeals level, or what would go through the court's mind on whether or not to grant the sanctions?
Well, let me just cut to the chase on that issue. Now, Morgan, let's put it this way. You and your co-plaintiffs were saying that the official story of what happened on 9/11 was false. In the case of Dr. Judy Wood, she was saying that exotic weapons in the form of directed free energy weapons destroyed the World Trade Center. In your case, you were saying that passenger jetliners did not crash into the World Trade Center. So those are the allegations and the claims that you were making. Essentially, Morgan, everyone else who brought a case and who made claims that were in any way similar to the claims that you made did get penalized with sanctions, meaning the lawyers and the parties who brought cases making claims of that nature were required to pay court costs and other costs, including just in some instances flat-out penalties for having made the claims that they made. The 17 lawyers who were arrayed against you made similar requests, and did so strenuously. However, their requests for sanctions were denied. I think the closest example that I can give you is that of April Gallup. April Gallup and her attorneys were unfortunately required to pay sanctions. Yet, if you look at it, April Gallup's case was based upon factual information. You know, she was present in the Pentagon. She was actually a victim. She was injured. But she knew that by being there, she saw no evidence that a plane had been involved in any way. And that is what she said. But even with respect to an eyewitness, at the end of the day, they ended up having to pay sanctions. You didn't. So the question is, well, why didn't you have to pay sanctions? And the answer is that your case proceeded in the way that the law allows. You brought a key TAM case based on information that was properly put into the public record at NIST. You vetted your information through a variety of sources, including, for example, the United States Directed Energy Directorate. You went to the United States Directed Energy Directorate and you asked them point blank, did directed energy weapons destroy the World Trade Center? And they did not say no. And as a matter of fact,
Dr. Wood's case.
Yes. Yeah. And as a matter of fact, they said, this is interesting. We wish we could help you, but we can't because we don't have enough resources. Well, first of all, you hadn't asked them for their help. You just asked them to say yes or no. Did weapons of that type destroy the World Trade Center? And they did not deny it. So I think it would have been hard-pressed for a court to grant sanctions against you because you had done nothing more than what you have the right to do, and you did it in a way by double-checking the accuracy of your facts to make sure that they at least met the threshold of what you have the right to say or do in bringing a case in court. Now, in addition to all of that, you put an enormous amount of information into the public record, both at the governmental website of the United States Department of Commerce, NIST, and in the court proceedings themselves. I mean, you know, each one of the submittals that we filed was, you know, probably on the order of 6 inches thick or more. So, you know, that information is there and is a matter of public record. So it's in those particulars, Morgan, that we are able to say that while, no, it was not a victory, it was not a complete defeat either. And I can tell you that among the lawyers on the other side, you know, there was a great deal of gnashing of teeth and wringing of hands over the fact that they didn't get sanctions. And I imagine that there was a similar process going on among their clients because this was obviously not an inexpensive case for them to defend.
Didn't you mention along the way that you detected one of the attorneys you opposed in these cases seemed to have some sympathy with the information or clients that you'd brought, that you detected a certain amount of weakness there for our position? Or
well, no, I did not put it that way.
No.
And the way that I put it was that we received a written communication from one of the lawyers where his ostensible purpose was to say that his client, ARA, Applied Research Associates, Inc., did not do the things that we accused ARA of doing. But guess what? In his written communication, he said the opposite. He said ARA did these things. So, was it a typographical error? I mean, I mean, that's, so that's what I said to you. I said that, look, if you're going to send, if you're going to put something in writing. Hello?
Okay. And these were, what do they call them? These zoot suit, high dollar, were these prestigious law firms, at least a few of them?
Well, yes, they were. And, from one end of the country to the next, New York, Boston, Los Angeles, Denver, all over the place, Chicago, to name some. But, it's all a matter of public record.
Now, you are a student of 9/11, and those cases were, well, I don't know when your Supreme Court was denied certiorari, but...
So that would have been in 2010.
2010,
yes, we took
okay.
the case, we took Dr. Wood's case up to the Supreme Court. That is to say, we applied for writ of certiorari, which was denied, and that marked the end of the case. However, once again, in order to apply for a writ of certiorari, you have to prepare, a fairly extensive application that is in the form of a brief. So that was done, and that too is that's the way the case is cited. It's Wood.
So in
the
you're a student of 9/11.
Yeah, let me just say that the title of the case is Wood and Others versus Applied Research Associates and Others. And then it has the various citations on where in the public court records the cases are to be found. It has a district court reference, a Second Circuit Court of Appeals reference, and a U.S. Supreme Court reference.
Now, you have to go into that legal digital system.
Well, the way you find it is through PACER, which, you have to pay for. PACER means, is an acronym for Public Access to Court Electronic Records, PACER. However, let Google be your friend. You can find, you can find the decisions and so on through Google. I believe, Morgan, you have many of the pleadings on your own website, the No More Games website.
Yes,
I believe,
yes.
Dr.
In terms
Wood,
of my legal file.
Yeah, and I believe you can find them also.
And she has, we are hearing some music, and here on the Reynolds Reveal, my guest today is attorney Jerry Leaphart, who is a 9/11 all-around good guy, very productive attorney at law. So come on back for our final segment. Welcome back to the Reynolds Reveal. My name, Morgan Reynolds, and if you would like to call in, this is the last segment with attorney Jerry Leaphart on this show, episode 25. The number 218-862-9829. Now, Jerry Leaphart, I'm thinking, well, we got maybe two topics we can squeeze in here at the end. And in our interview, the first one is a little bit more about 9/11, the gift that keeps on giving, and is the immediate cause of all the national security state. We need to discuss some more. But back nearly 3 years ago now, I did an interview with you, and I thought you had some insightful things to say about the 9/11 facade. Is going to break sooner or later. You were expressed confidence in that. Yeah, we do have our media lapdogs and the whole. but it looks like it's coming unstuck at a lot of the levels, and perhaps most importantly, because of the Edward Snowden revelations. And now I think the public maybe, not in the not too distant future, may be able to make a fundamental reassessment. We see this whole NSA thing, just lie after lie, and then they're backtracking and back. Maybe we're approaching the tipping point you referred to. And it also is true that the truth is cathartic. There's a soft underbelly here that is gnawing at the gut of America. It's called 9/11. How much of that is on point, do you think?
Well, in a word, yes. 9/11 and the recognition virtually from the outset that this was a fantastical event that made no sense has continued to percolate and to bubble. There are a lot of anecdotes to that effect, and the fact is there remains an active and viable the 9/11 truth movement. Now, I don't know that you or I ever really consider ourselves to be active members of that because it has taken on a political context, and there are certain things that you have to believe if you're an active part of some elements of that community. And it's also, I think, fair at this point, Morgan, to acknowledge and to admit that that there are elements within that community that consider the likes of you and me and Dr. Wood to be co-intel pro, or to be purposefully misleading the public so that it discredits the 9/11 truth movement. And notwithstanding that, you are the only ones who actually, put your information, into the public record. And that is something that, if it were propaganda, then at least until very recently, there were prohibitions against governmental agencies who might issue propaganda or false information for external, or that is to say for foreign consumption. You could not use that information, for domestic purposes, and you could not put that information into the public record in, for example, U.S. courts. Now, the odd piece of business here is that that prohibition was recently eliminated. So that now, if you are
Jerry, the most recent development. Yeah. No.
Hello?
Yes, Jerry, go ahead.
Yeah. But the fact of the matter is that while the prohibition against putting propaganda into the public record was still in effect, that is to say, when it was illegal to do that, you and Dr. Wood put your information into the public record. So go figure. Now, at that same time, some other activists who were making these accusations against Dr. Wood and against you did not put their information into the public record, even when they had a chance to do so. Let's put it this way. Let's just set the record straight here. Morgan, you, Dr. Wood, and Edward Haas were the first ones to use the NIST procedure to object to the report that they were going to issue. You called it false. Okay? When you did that back in, I believe, 2006, 07.
07.
Yeah. That was during the time when the debate amongst 9/11 truthers as to, who was COINTELPRO and who wasn't was raging. So you struck first. You put your information into the public record at a time when to do so, if it were false, would have been illegal. Thereafter, some others who had been making that accusation also put something into the public record at NIST, but interestingly, it did not include the essence of what they were saying had caused the Twin Towers to annihilate, to self-annihilate. They did not put that information into the public record. So I want that out there, for those, and, this whole thing about, I won't say anything that would get me in trouble, so therefore I don't care if they're spying. That mindset, I think I've heard that one almost as much as I've heard the mindset, your clients are COINTELPRO. Well, they're not. And the public record is very clear that you put your information out there into the public, went to the court with it, where you were making the representation that what you were saying was true, and where if you had not spoken truthfully, then you would have gotten sanctions, and you did not, despite the best efforts of some of the largest law firms in the country. So that's what the public record shows, Morgan, and I think you have every right to be proud of it.
Well, I think I'm bulletproof on that front. I've got some people with an internet connection who claim, for example, that when I was chief economist, I was the new chief economist at the U.S. Department of Labor for 1 week when 9/11 happened. And I'm thinking about one guy in particular. He says, Reynolds was in the White House with Ted Olson making 9/11 happen. Well, of course, if that were true, he could prosecute or find a way to sue me or prosecute me under the Smith-Mundt Act that you're referring to.
Correct.
I'm bulletproof on that front. Well, anybody can say anything, and they have on the internet.
Right. Anyone can say anything, and they have.
And they will. So let's go to the more general, one of the major effects, of course, is our national surveillance state. You wanted to make further comment about where we are and where we're headed on that front.
Yes. Al, what is so very interesting is that there's something I have not mentioned, and that is that governmental entities consist or are staffed in part by governmental employees, but much of the work that is done is contracted out. We use the phrase public-private partnership to describe the process by which so much that is done under the auspices of governments, the federal government in particular, is actually performed or done and paid for by hiring corporate outfits of one kind or another, and they range from giant to small. Edward Snowden was employed by one of the large defense contractors, Booz Allen, which in turn might or might not be a subsidiary of an even larger entity like a Halliburton, or affiliated in some way with SAIC or ARA, among others. It's important to note that there are as many people who are actually corporate employees who have security clearances as there are governmental employees who have such clearances. That's a lot of secrecy and a lot of layers. And
huge. And they can keep a big conspiracy together in because of secrecy. Well, poor Jerry Leaphart, it didn't get the last word in, but we got a lot of very insightful words out there during our show, and I thank you so much, Jerry Leaphart, for coming on the Reynolds Reveal.
Morgan, it's been my pleasure as always. Awfully good speaking with you.
Thank you for everything you do. Come on back next week. I think we're going to do economics, which can't be.
Sounds good.
From Western New York State and the Niagara Woodland Campground, only 20 miles from Niagara Falls, comes the Reynolds Reveal, the show that sifts and winnows without fear or favor. Good afternoon, ladies and gentlemen. I am your host, Morgan Reynolds, and we here at the Guerrilla Media Network thank you for listening in. Today is August 21, 2013, and this is episode number 25 of the Reynolds Reveal. Regular listeners know that I'm on an extended camping trip, trying to avoid work. Even a retiree, we can escape. Yet I'm trying to do the Reynolds Reveal on the road. Now, sometimes this works, sometimes not, and we were a little shaky here at the beginning, but I'm hoping we can complete our 2-hour show. Yesterday, my wife Pat and I visited Niagara Falls. That's my second visit, but I spent more time. And it was a great time ogling the Horseshoe Falls and the Bridal Veil Falls, the whole works. And to see 4 Great Lakes empty into the Niagara River and into Lake Ontario, it is just incredible, a feat of nature. And today we went to the old Fort Niagara, and that was very enjoyable because I think I know a thing or two about U.S. Colonial history, and yet I didn't know really about Fort Niagara, although you think about it, yeah, this is a choke point, and water transportation being so much cheaper than hacking your way through the northeast woods and the mountains. It was important to hold, and learned about the British throwing out the French, and then the Americans throwing out the British, etc. And it's just really some great stuff. So I recommend touring in this area. So I've had an enjoyable time. Maybe I haven't done my homework here quite as intensely as I ordinarily do. Okay, so my special guest today on to business is Counselor Jerry Leaphart, or Esquire, an attorney at law. And I guess lawyers somehow since Shakespeare or before acquired this negative reputation, but here is a man that I can endorse without reservation, Jerry Leaphart. He's a resident of Connecticut near New York City and therefore New York State. He's a graduate of the law school at NYU back in 1971. And
not immediately jump into speculation or into conspiracy. When you do that, you're always guessing, and when you're guessing, you're probably wrong, and therefore easily marginalized for good reason. So one of the additional benefits of what Edward Snowden has done is that it has revealed that much that would have been dismissed before his revelations as mere conspiracy theory are now revealed to be fact. So that gives us something to work with. Now, you mentioned that.
And now here's a thought. I want to let's speculate for a moment, despite your negative claim about that. But somebody made the point in an article I was reading this morning about how hard they're fighting. For example, they detained Greenwald's domestic partner, whose name escapes me, David in Heathrow.
David Miranda.
Miranda.
That's extraordinary.
And it's an intimidation ploy, at least in part. And the writer was saying, why they going so hard. They've been exposed in lie after lie about NSA behavior, and the thought occurred to me. They have to cover up. 9/11 is the biggest crime these guys have committed. Something could come out. Who knows? That whistleblowers reveal inside. It's just an important thought, I think, about their motivation, about why whoever is heading the executive branch has got to go so hard after a Snowden or anybody else.
Well, this issue of how hard they are going after Snowden and anyone connected with him, Greenwald, Miranda being the two current examples. But let's explore that a little bit, Morgan. Put yourself in the position of, once again, I might add, of being a high governmental official with a security clearance, and let's assume that you have access to classified information, compartmentalized information, and that something about things that are going on that are presented one way, but in public, but are quite the opposite based on the information you have access to. One can you don't have to imagine to be able to know that at this point, virtually all of the nearly 1 million people who have security clearances are probably being placed under extraordinary additional scrutiny themselves. I mean, if anyone with a security clearance at this point sneezes at the wrong time, they're probably going to come in or come under additional pressure. Now, I think, Morgan, that it is precisely because of pressures like that at some point additional whistleblowers will more likely come forward. It's the system based on what Snowden has been able to accomplish, and to a lesser extent in terms of consequences to the individual, what Bradley Manning has been able to accomplish, do suggest to us that people who are on the inside, who have access to this information that they know is proof of intensely illegal, not to mention unconstitutional activity, are at this point, I think, the considered to be the among the greatest threats to the power structure and the powers that be.
But now, Jerry, you, given your special skills, training, and experience, you approach this, at least in part, as an attorney, and can take actions in the court system, which is it's a privilege and potentially a powerful way to proceed. So what are you doing specifically with the NSA?
Well, specifically with such that it's virtually impossible for even officials at the highest governmental level to fully know or apprehend what is being done under their watch or in their name, let alone in the name of the people that they purportedly represent. The NSA revelations, which came about as the result of the actions of a whistleblower, are, I think, crucial in the sense that the status of whistleblower is one that we should probably revere. I think it was...
Yay! Yay for the whistleblowers. Yeah. I mean, how can a republic or a democracy really operate successfully if so much is done in secret? It cannot be done.
No, it truly is a staggering danger. One about which we've had numerous important warnings over the years. One that of course stands out and is frequently mentioned is that of then President Eisenhower's January 1961 military-industrial complex warning. He was, and he said it in such a deadpan, matter-of-fact fashion that both at that time and even now, it's very difficult to come to grips with the full meaning and the full significance of what was being said at that time about the power of these entities to not just shape events, but to do so in a manner that is just amoral.
Yes, that's the first level to talk about before illegalities or unconstitutionalities. Yes.
Yeah, I mean, those are just obstacles for them. So it's I try to phrase my thought about this matters of this nature in a way that does not.
He tells me his first 20 years or so were spent as a corporate lawyer in the energy industry of all things. And you're going to learn more about how he has taken the other side of the energy industry in court. So, Jerry Leaphart, welcome. It's an honor to have you on the Reynolds Reveal.
Well, thank you, Morgan. As usual, it's good to be with you. After you listed out my embarrassing background, I don't know quite where we're going to take it from there, but all right. You did it, so now...
we're going to be lifted by your acumen and wisdom and experience. I'll tell you, I have an interview with Jerry Leaphart on my blog called NoMoreGames.net, and I read that, finished it today, and there's an awful lot of insight there. That was back in 2010, so it's been almost 3 years. But let's go to more immediate matters. I do want to review much of that material because it's important. So few people know about our federal cases involving the substance of 9/11 and the fraud thereof. But I got an email from you today, and you are acting against NSA or to reveal what they have snooped up on you. So tell us about that.
Well, Morgan, we all knew in our intense review of what happened in connection with the events of 9/11 that it was important to stay on the trail because other events that would be as catastrophic or as alarming would continue to take place in the absence of vigilance. Now, on one level, the revelations concerning the extent to which we are all being spied upon by NSA are important in their own right. These events are also representative of an ongoing issue, an ongoing problem of having a governmental apparatus that cloaks itself and its operations